Hello, good day everyone. Good day, attorney. This video is a presentation of Group 1 discussing a special penal law entitled Penalizing Obstruction of Apprehension and Prosecution of Criminal Offenders. This is a requirement for Criminal Law 1 under Attorney Annabel Mindalano. But first, I present to you our group members for this task. I work together with Kalala, Makadato, and Abbas. To begin, I will be presenting to you the introduction for this law and its significance. Obstruction in its literal meaning means hurdle, obstacle, a barrier, a block. If any person willfully obstructs, impedes, frustrates, or delays the apprehension of suspects or the investigation or prosecution of criminal cases, or intrudes in a criminal scene, he commits obstruction of justice. This is where PD 1829 comes into the picture. This law was enacted in 1821 by President Marcos. Justice is essential in maintaining peace and order because due process in investigations and prosecutions must be observed. Justice is only considered served when a criminal receives punishment appropriate to the criminality of the act he committed. The purpose of this law is to discourage public indifference or apathy towards the apprehension and prosecution of criminal offenders.
Okay, what are the punishable acts under PD 1829? Okay, the first act punishable under PD 1829 is preventing witness from testifying, reporting, or identifying the suspect by means of bribery, misrepresentation, or intimidation. So to illustrate, let's say Mr. X witnessed the crime of murder and wanted to report the crime, but Mr. Y offered 1 million for his silence, or Mr. Y threatens Mr. X that if he will report what he knows, something terrible will happen to him and his family. So in both scenarios, Mr. Y is committing an offense of obstruction of justice. In the number one by means of bribery, and then number two by means of intimidation or and threats. Okay, the second act punishable under PD 1829 is altering, destroying, or concealing the evidence. So to illustrate, let's say a murder was committed by Mr. X, which was caught by the CCTV of Mr. A. Police investigators came asking for a copy of the video. So let's say Mr. A gives an edited video, so that is alteration. Uh, Next is if Mr. A deleted the video, though, so that is destroying the evidence. Let's say instead Mr. A did not furnish a copy to the investigators, so that is concealment. So in all three scenarios, Mr. A may be liable for the offense of obstruction of justice. Uh, Okay, the third act punishable is somehow related to Articles 19 and 20 of the revised penal code. Although in Article 20, there were certain individuals who are exempted from criminal liability, such as spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees. But in this special law, it doesn't matter whether you are the spouse, ascendants, descendants, or anyone, as mentioned earlier, you will still be liable for the offense. So it seems like RPC and this special law are in conflict. So as we all know, in case of conflict between a general law and a special law, the special law shall prevail. So although those persons mentioned are exempted from criminal liability under the revised penal code, they may still be liable for the offense of obstruction of justice under Presidential Decree 1829. Okay, so the fourth act punishable under PD 1829 is using fictitious name for purpose of concealing a crime or evading prosecution. So to illustrate, let's say Mr. X is being prosecuted for murder. To avoid prosecution, he hid and used fictitious name to evade prosecution. So aside from the crime in which he is being charged, which is the murder, he may also be liable for obstruction of justice under PD 1829.
Delaying the prosecution of criminal cases by obstructing the service of process or court orders or disturbing proceedings in the fiscal's offices, in Tanod Bayan, or in the courts. It talks about the action of the non-parties who are beyond the traditional reach of contempt sanction. To support a conviction, there must be a proof that the defendant had the actual knowledge of the court order and intentionally obstructed justice. Making, presenting, or using any record, document, paper, or object with knowledge of its falsity and with the intent to affect the course or outcome of the investigation of or official proceedings in criminal cases. There is the intention to mislead the public officials to prevent prosecution by presentation of false documents in order to obstruct the process of the proceedings of the investigation. Soliciting, accepting, or agreeing to accept any benefit in consideration of abstaining from discontinuing or impeding the prosecution of criminal offender. This particular subsection of PD 1829 is similar to the paragraph of the paragraph 3 of the Article 210 on direct bribery, which penalizes the public officer when the act of bribery constitutes the act of refraining from doing something which it was his official duty to do, threatening directly or indirectly another with the infliction of any wrong upon his person, honor, or property, or that of any immediate member of or members of his family, in order to prevent a person from appearing in the investigation of or official proceedings in criminal cases, or imposing a condition, whether lawful or unlawful, in order to prevent a person from appearing in the investigation of or in official proceedings in criminal cases. It is self-explanatory as it talks about the threat to prevent a person from appearing in the official proceedings in such criminal cases. Giving of false or fabricated information to mislead or prevent the law enforcement agencies from apprehending the offender or from protecting the life or property of the victim, or fabricating information from the data gathered in confidence by investigating authorities for purposes of background information and not for the publication in publishing or disseminating the same to mislead the investigator of the court. This subsection penalizes harboring or concealing or facilitating the escape of any person he knows or has reasonable grounds to believe or suspect has committed any offense under existing penal laws in order to prevent his arrest, prosecution, and conviction.
I'm going to discuss about penalty for violations under Presidential Decree 1829. It is an act to further strengthen the apprehension against the obstruction of justice, amending for the purpose in Section 1 of Presidential Decree number 1892, otherwise known as Penalizing Obstruction of Apprehension and Prosecution of Criminal Offenders. It was enacted by the Senate and House of Representatives of the Philippines in Congress, assembled. Section 1 of Presidential Decree 1829 is hereby amended to read as follows. Section 1, the penalty of prison correctional in its maximum period, or a fine ranging from 1,000 to 6,000 or both, shall be imposed upon any person who knowingly or willfully obstructs, impedes, frustrates, or delays the apprehension of suspects and the investigation and prosecution of criminal cases. In case a public officer is found guilty, he shall also suffer perpetual disqualification from holding public office. Application of Presidential Decree 1829. In order to further demonstrate the actual application of the Presidential Decree 1829, I will discuss the case of Posadas versus Ombudsman and Enrile versus Amin. Posadas versus Ombudsman. Into the case of Posadas versus Ombudsman, certain officials of the University of the Philippines were charged for violating Presidential Decree 1829. The UP officer subjected to the warrantless arrest of a certain students by the National Bureau of Investigation. According to the Supreme Court, the police had no ground for the warrantless arrests. The UP officers, therefore, had a right to prevent the arrest of the students at the time because their attempted arrest was illegal. The need to enforce the law cannot be justified by sacrificing constitutional rights. In another case, Senator Juan Ponce Enrile was charged under Presidential Decree 1829 for allegedly accommodating Colonel Gregorio Honasan by giving him food and comfort on December 1, 1989, in his house. Knowing that Colonel Honasan is a fugitive from justice, Senator Enrile allegedly did not do anything to have Honasan arrested or apprehended. The Supreme Court ruled that Senator Enrile could not be separately charged under 1892 as this is absorbed in the charge of rebellion already filed against Senator Enrile. So that would be all on behalf of our group. I'd like to thank you all for listening.